Hello and welcome to Moneylife. This is Sucheta Dalal. This week we're going back and revisiting the issue of consumer justice. In fact, a few months ago, I said AI is changing the way the consumer redress works. But this week, I'm telling you that high profile orders and the AI hype cannot hide a broken consumer justice system. And it is indeed broken. You will never figure that out if you just read the newspaper headlines. In fact, in the last 6 months, the National Consumer Disputes Redressal Commission, NCDRC, which is the apex consumer body, it goes through three levels: district, state, and then to the center, as well as the Supreme Court of India, have delivered several consumer friendly rulings on real estate delays. This is a heartening development because housing remains the single biggest investment for most middle class Indians, and yet it is one of the top categories of consumer complaints, along with, of course, insurance, banking, etc. Now, on 20th February 2026, the Supreme Court dismissed an appeal by Parsnath developers and upheld an order of the NCDRC. Now, like I said, District Commission, State Commission, NCDRC, you can still file an appeal to the Supreme Court. That is the number of levels through which we as consumers have to fight if we want justice, with a powerful body on the other side like this builder. But what the court did was it slammed one sided builder buyer contracts, and it said that home buyers cannot be forced to take occupation of their flats unless there is a valid occupation certificate. In this case, it directed Pasna developers to obtain an OC, an occupation certificate, within 6 months, and to continue paying interest at the rate of 8% until they formally and legally hand over the flat. A similar order is already pending in the NCDRC. I don't know whether it will be challenged at the Supreme Court, but in October 2025, the NCDRC ruled against Mantra Lifestyle Homes of Jaipur, directing full refunds with 9% interest for chronic delays in possession and the same occupation certificate issue. In parallel, there is another set of things that we feel very happy about, which is an investigation done by the Central Bureau of Investigation, the CBI, directed by the Supreme Court. The Supreme Court is probing the unholy nexus between builders and banks. Now, following SC directions, the CBI has been raiding a number of banks and builders, as well as the Enforcement Directorate, which has attached properties. These include JP, Supertech, Vatiga, Anjanara. 28 or so FIRs have been registered since July 2025. The core allegation here involves interest subvention schemes. Now, you know that builders have been tempted people to buy even when things are not ready by saying, don't worry, I'm guaranteeing you possession. I will pay the EMI. You take the loan, invest, I'll pay the EMI until I hand over possession. Lots of people thought it's fantastic because there's no responsibility. The EMI, which includes in the beginning only interest, but a portion of the principal, if you look at it as an equated installment, why won't you accept it? It then turns out that builders defaulted on the loans. They had a nexus with banks. Banks immediately began to force the customer or the home buyer to service these loans with no sign of possession, no sign of completion. And this could only have been a nexus because they ought to have been looking at whether this builder had the resources, had the intention, and was in a position to complete the building and handover position as planned, because they're paying EMI, right? If you're sticking your neck out to that extent, a lender, which is a bank in this case, needs to be doing his due diligence and had clearly not done it because they know that they can recover it from the hapless home buyer. Again, these actions signal growing regulatory and judicial scrutiny. You feel happy, you think, oh wow, there is justice being done. But most of us who read the headline don't know the enormous pain going back maybe 7 or 8 years to reach this stage. These high profile interventions are just an incomplete picture about the state of consumer justice. The ground reality has been brought out by a very interesting report, the Consumer Justice Report 2026, assessing capacity of redressal commissions in India. It's part of the India Justice Report 2026. Very sobering. First, it points out, like I said, housing and realty are among the top complaints. Insurance, banking, e-commerce are the other three that dominate this area. All of us as consumers end up languishing in dysfunctional district and state consumer forums, which are riddled with vacancies and pendencies. Who's saying this? Not me. This is part of that consumer report based on right to information filings and parliamentary reports that they have tracked. Now, as I said repeatedly, and it's worth mentioning, you file a complaint, depending on the amount, it first goes to a district commission. Then it is challenged at the state commission, because usually a larger, bigger, powerful party on this other side doesn't pay up. Even if you win at the state commission, it goes to NCDRC. Even if you win there, it goes to the Supreme Court, depending on how powerful the person is on the other side. There are very few who realize that they have done something wrong, they're interested in you as a consumer, and say, okay, we goofed, we've got a ruling against us. Frankly, it shouldn't even come to a stage. If consumer service and customer service is good in any company or organization, you should not have to go to a consumer court at all. But because you haven't got justice, you go there, right? Otherwise, you just call up the company and complain and have issues resolved. Once you reach there, it's such a hurdle race. Now, consider some of the findings in this report. More than half the posts of president and member of the 35 state consumer commissions were vacant in 2025. If you don't even have a president and member, you can't even argue. There are no hearings. Only 4 had a full complement of top officials. Shocking, right? Until all of them are there, there's no valid order. Some state commissions had no staff at all, while staff vacancies averaged 20% across the board, across commissions in the country. Consequently, pendency of cases jumped 21% in the 5-year period that was tracked between 2020 and 2024. Now, you have to look at this against the statutory promise of consumer cases being decided in 3 to 5 months. That was what was promised in the Consumer Protection Act, where it was originally brought in. 3 to 5 months. In fact, 1 in 3 cases remain stuck for over 3 years. And as I've said before, it doesn't stop at that. 90% of the people just abandon the case after 2 years because they say there's no point. You go tariq pe tariq, there is no appointments, you're not going to get justice, and people just live with the problem. Now, the next big promise that was made in 2019 when the Act was amended was that you will have mediation and lok adalats as the game changer or the flagship reform. This was done in 2019. In reality, both these aspects have been largely ignored. So 14 state commissions, including the better ones, Karnataka, Rajasthan, West Bengal, did not refer even a single case to mediation since 2022. That means they don't care. This was the game-changing part. They don't even think one case has to be referred. In fact, many commissions have zero budgets allocated for mediation. They don't even have mediation panels. Consequently, reference to mediation and lok adalats has collapsed over the years. So look at the irony. You need to have a panel first. Then you have to refer a case for mediation. Only then it can happen. So neither are panels complete, nor are cases referred. And obviously, this whole game-changing amendment is collapsing. The report describes mediation as symbolic rather than substantive. In a system that's already strained with rising complaints, the near total neglect of these faster, cheaper alternatives really defeats the Act's purpose. It also aligns with the broader evidence we have found. Like I said, 90% of the people do not want to wait for a consumer issue over 2 years. When they see that there are no hearings, they're wasting their time, they just drop it. And this, in effect, means that the system is designed to exhaust you as a complainant so that you're out, and then the numbers are based on that it's resolved, it's over because you didn't show up, the case is thrown out. The same pattern repeats in the Real Estate Regulation and Development Act. RERA, again, touted as a game changer. So if you have maximum number of complaints in real estate, they said, okay, we're giving you a new act. The center can't do anything much other than the act because it's a state subject. So state had their own RERA, like we have in Maharashtra, you have MahaRERA. Every state has its own version of the RERA Act. There's a central RERA Act, and everything is riddled with backlogs. Pre 2025 cases have been cleared, but nationwide, over 1 lakh RERA complaints remain unresolved in several states, forcing homebuyers into prolonged battles. Now, we've talked about real estate. Let's look at what happens in other two areas that concern us, which is food safety and medicine. There's been an explosion of scandals in the safety of food and medicine. Social media amplifies this. None of us are going to miss it because you have all these reports made into reels and you're watching them with a lot of drama. It's all true. There's large scale adulteration of food and medicine. You know the cough syrup deaths that have happened repeatedly. Nothing much happens. There's some ex gratia, people land up. There are news stories which last 3 days. And we begin to question the one positive impact of all this negative news, as the government may call it, is that we as people have begun to question the Food and Drug Administration, the Food Safety Standards Authority of India. We're beginning to ask, what is it that you are doing? Are you checking enough? And so you have more reports about action taken by them as well. So not a day goes by without reports of adulterated milk, paneer, ghee, mango pulp, cough syrups, expired medicines which are relabeled and sold again, all kinds of scandals which are playing with our health. There's national outrage, leads to headlines, and a little bit of action. So you'll have photos, say, from Pune of adulterated mango pulp being dumped into groundwater. Or you have the CBI filing a case on the Tirumala Tirupati Devasthanam, where for 5 long years they supplied some palm oil based emulsification as pure ghee to make the Tirupati laddus that people swear by, stand in queue to get. And this is what you were getting. CBI has also arrested some FSAI assistant director on bribery involving a private laboratory. Now, why would a lab bribe? Because it is passing or giving wrong certificates which affect you and me. But FSSAI's own data shows that 17% of food samples fail safety standards. They are taking action, not enough because it's too widespread, and it's not hard enough that people are scared to repeat it. So, despite actions like recalls, penalties, large scale adulteration continues. More importantly, FSSAI can ban manufacturers, can impose fines. This doesn't help you and me. If I'm affected, I've fallen ill, I've gone to a hospital, I want justice, I have to separately go to a consumer court. If there's a scandal and there are deaths, the government will announce an ex gratia and put a price of 1 lakh, 2 lakh, 5 lakh to your life. That's not what you want. You want to fight for your rights. You have to go to a consumer court, which may be at the district level. Then you go to the state level if they fight back, then the NCDRC. And in about 6 or 7 years, if you're lucky, you can hope to get justice or delayed compensation or whatever. Can any of this be fixed with artificial intelligence? Yeah, sure. Our AI helps. So it has helped to upgrade the National Consumer Helpline. It can sort complaints, it can send them out faster. You can have chatbots like Grahak Nyay on the eJagriti portal, which will help you file better complaints, get your facts in order. But having sent it, having got a complaint there, maybe when the numbers are large, the National Consumer Helpline will do a class action and talk to the company. But individual one off cases, you have to go back to a consumer court. So, in an earlier column in February, I had noted that use of AI has facilitated refunds worth tens of crores. It has dissolved 1 lakh grievances. This is useful, but it's only a supplement. AI cannot fix structural bottlenecks, which the consumer survey report has pointed out. A chatbot cannot point precedents and members. It cannot utilize lapsed budgets. It cannot mandate mediation referrals, or even in a 50 lakh adulteration or housing fraud case that's already pending for 3 years, what can a chatbot do? You just have to wait from one tariq to another. Without time bound appointments, full coverage, as in full staffing at the district level, 1 in 10 districts still lack a district commission, consumer dispute resolution commission itself. Unless you have enforced mediation, transparent data, Just technology and AI are buzzwords. They cannot deliver timely and effective redress, which is what the Act has promised you in 2019. In fact, high profile NCDRC orders, CBI probes, FSSAI penalties make for compelling headlines. AI chatbots and digital portals make for reassuring press releases. Some states, such as Andhra, Madhya Pradesh, and Rajasthan, indeed show better performance in terms of the ranking in the report, but it is not a national statistics. Consumer justice overall remains weak. Consumers have to wait for a long time for redress, or they're abandoning cases, and this is at the cost of our health, our savings, and our trust in the government. Unless the government focuses on appointing full benches, and you hear endless discussion on this if you follow Supreme Court decisions, but it has to be done on a war footing because that shows a government that cares. Then we come to enforced mediation and every district having a consumer forum that functions, has the right staff. And finally, FSSAI should stop treating whistleblowers as adversaries. All of us who criticize are looking for betterment and improvement for people like you and me. It is only when you challenge the government that they're going to act. So if you agree, please share, subscribe. Thank you.